Good morning. My name is Olivia Barris, and I am one of the trainee solicitors at Ashton and Wilson. My task today is to provide you with a briefing on the case of RVABJ and how it connects to our client. The facts of the case are as follows. In RVABJ, the appellant was charged under Section 121A of the Terrorism Act 2000. The charge arose from a speech she delivered in Brighton City Centre on October 8, 2023, during a Palestinian Solidarity Campaign event. It is alleged that although she did not explicitly voice support for Hamas, her use of certain phrases amounted to expressing an opinion supportive of a prescribed terrorist organization. Now, this appeal was heard jointly with RVBDN. In this case, the second appellant was also accused of expressing support for Hamas. His alleged conduct involved holding a placard and giving a speech outside the gates of Downing Street on October 17, 2023. His preparatory hearing took place at the Central London Criminal Court, and similar to ABJ, also concerns about a violation under Section 121A of the Terrorism Act. Now, the legal issue in both cases stand the same. Has the Terrorism Act 2000 directly breached their rights under Article 10 of the European Convention of Human Rights? Additionally, is the requirement of the mental element compatible with this case? Now, let us examine the reasoning of the court. Initially, both respectable Crown courts ruled that the offense does not require proof of the defendant's knowledge about the organization being prescribed, meaning the ingredients of the charge were enough for it to be constituted as a crime. Both cases were then later dismissed by the Court of Appeal Criminal Division, which cemented the previous ruling that Article 10 of the ECHR concerning free speech was not violated. Connecting back to RVABJ, despite not having a definitive authority for the court's reasoning, a similar case, RV Chattery, was used as guidance. This case dealt primarily with the issue of knowledge and conclusively decided that although Chattery knew of his support for ISIS, RVABJ and RVBDN were just as guilty on the basis of recklessness. Now, there are multiple components that must be acknowledged in order to connect any laws to this case. Primarily focusing on RVABJ and the doctrine of common law, there's mention of two specific ingredients required for prosecuting under the Terrorism Act. These include the requirement that the defendant must have expressed support for that organization and that there was some form of recklessness in that expression. In addressing these ingredients, I would like to draw your attention to paragraph 16 and 53 of the judgment in RVABJ, along with the interpretation of Article 10 of the ECHR, admissibility of evidence, and the principle of mens rea. For starters, in paragraph 16 of the RVABJ judgment, both the prosecution and the court focused on the idea of invitation. In other words, the defendant would need to show either deliberately or through carelessness that their comments were supporting the organization. In Craig's situation, just talking about climate change does not mean he is backing take action, but rather he's simply sharing his views on environmental protection. RVABJ helps us because even though support is not defined in the statute, the court treats it as needed by some kind of encouragement. That lets us say Craig's comments do not come close to that line, as any passionate person can participate in climate activism. Okay. As explained in paragraph 53 of the RVABJ judgment, the court made it clear that talking about a group or mentioning them by name does not necessarily mean they are showing support. Applying that here, Craig's comments, which the prosecution may say show support, are not nearly as strong when you look at what he was actually doing. He was simply referring to Take Action's work. A reasonable person would recognize that yes, Craig did name Take Action, but only as part of setting out the background of environmental activism and not pushing its agenda. Another specific argument concerns the admissibility of evidence. In the UK, social media can be used to find corresponding evidence that may demonstrate guilt. What truly matters is its context and whether it is complete. In Craig's position, he did not ask the audience to look up to take action. However, his speech was clipped and distributed on social media platforms that could easily be manipulated. We could argue that this is in fact an example of misleading information. Now, I've included a quotation from Article 10 of the European Convention on Human Rights to help support this point. Article 10 states that everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. In this respect, when a speech is taken out of context and not considered in its entirety, it risks turning ordinary expression into something that appears incriminating. This could be a valid defense for Greg, as his entire speech was not posted. Diving deeper into incompatibility in Article 10 of the ECHR, I want to focus on proportionality and how it applies to Craig. EU law protects a person's right to express themselves unless the state can show that restricting that expression is necessary. For Craig, punishing or restricting his speech is not proportionate because he was calling for environmental change. His comments fall within the sphere of political discussion aimed at improving society. In his speech, he highlights the need for change, but he does not call for violence, thereby making it a peaceful protest. Beyond that, Article 10 strongly indicates that political debate is protected even when it is controversial. Against that backdrop, criminalizing Greg for expressing political support for climate action seems extreme, and any justification for doing so can be seen as excessive. Outside the scope of Article 10, the doctrine of mens rea directly relates to Craig's lack of knowledge that Take Action was a prescribed organization. As noted in RVABJ, the court made it clear that Section 12 is not a strict liability offense, and it does require mens rea for conviction. Unfortunately for Craig, the fact that he spoke about Take Actions, even without knowing its prescribed status, could still to a degree amount to recklessness in the eyes of the jury. However, this is not the end of Craig's defense. We can argue an important point, and that is if recklessness is being used as the mens rea, then the prosecution must show that Craig was willing to take the risk. This requirement gives Craig room to challenge whether he truly met the threshold. As we know, Craig was abroad for a year and had no idea that Take Action had been identified as a terrorist group. That said, for recklessness to apply, he would need to have unreasonably ignored the venture. But that did not happen here. Even though there was a lack of knowledge, and that is not a strong defense on its own, it would still make it difficult for the prosecution to prove that Craig consciously took that risk. To end off, I would like to briefly summarize the key arguments that form our next steps. These include the fact that Craig was merely discussing climate activism and not supporting a prescribed organization, and that Article 10 protects his political speech and makes his restriction incompatible. Additionally, the clipped montage of his speech should not be admissible, and the mens rea element has not been fully established. Although the case is somewhat similar to RVABJ, our key facts should not warrant a conviction. That concludes my briefing. Thank you all for listening, and I'm happy to be of assistance as the case progresses. Now, I have shared my table of authorities and included references to all the sources that were useful for this case briefing. You are more than welcome to read them to see where my arguments came from. Now, my reflection. Reflecting on my work, I want to talk about the strengths and weaknesses. To begin with, I think it's important to first point out the parts I should have worked harder on. In the past, I have been a bit lenient with myself when it comes to critical thinking and forming strong arguments. In the future, I plan to further support my points and write my case briefings with more confidence. I admit that if it were not for the time restrictions, I would have included more secondary sources that contributed to EU law, as well as more creative perspectives from those articles. I also think I could have gone deeper in my application of the law by engaging with additional case law, especially to strengthen my analysis of proportionality and recklessness. On the other hand, I am proud of my written presentation. I used to think that the more information you put on a slide, the easier it is to understand. But I've realized that is not true. In fact, it was rewarding to challenge that mindset and focus on a concise way of presenting my points. Furthermore, I think I've developed a stronger appreciation for reading precedent and applying past judgments such as RVABJ in this case and in future work. In any other situation, I would have just researched the law in general without making any meaningful connections back to other cases. Thank you very much.